invitation for me to be on this wonderful panel today. I'm delighted to be here with all of you and with my co-panelists. So as we embark on this multi-month, probably multi-year process, I think it's important for us to take a few steps back at this moment in time and ask ourselves again, what are our overarching goals with respect to NAFTA renegotiation, but trade policy more broadly, and the U.S. role in the global economy? Because I think these things are all connected to each other. And one of the things that I heard this morning is a little bit of a sigh of relief from folks in this room that the 17-page document that came out on Monday basically looks a lot like Fast Track, and it looks a lot like TPP. And I think everyone's saying, phew, it's just going to be more business as usual. And, in one sense, fine, there's relief. It's not going to be a complete chaos or train wreck. But on the other hand, I think we do have to ask ourselves, if we don't address some of the underlying issues that have raised the concerns that got Donald Trump elected president, are we really winning? And I would argue no, because I do think, and I think it's not a surprise to folks, that the labor community and the environmental groups and consumer and a lot of other groups have been critical of our trade policy, not because we don't want to trade with the rest of the world, but because we think that the set of rules are imbalanced and problematic. And I'm not sure what we see in the 17 pages that would lead us to believe there's going to be a kind of deep changes that might actually address the underlying anger, concerns, the inequality, and some of the problems. But and I think it's interesting, and I think it's good for all of us to stop and to say, first of all, what would be our ideal goals if we were king and queen of the world in terms of NAFTA renegotiation? Then also, as everybody I think today has talked about, what is, in the real world, what is possible given the world that we live in and the real constraints that we have two real countries, Canada and Mexico, with their own domestic political objectives, their own economic objectives, and that, as Matt pointed out, we need to reach consensus. We cannot really force an outcome on anybody. But when the labor movement's problems with NAFTA, our criticism of NAFTA, I think are pretty clear. We've laid them out a lot. That it's, first of all, not a question of whether the United States is the winner or the loser in this particular trade agreement. Because in our view, countries are not winners and losers in trade agreements. And that framework, which is the Trump administration's framework for the most part, is faulty. Because we have groups within countries. So you have workers in the United States and Canada and Mexico. And you have small producers, and you have family farmers that are experiencing some of the same stresses and problems from trade agreements like NAFTA. And then you have the multinational corporate sector, which is experiencing a lot of the benefits. And that corporate sector crosses the borders as well. So that's my first framing point. And we would argue, and I know a lot of people here will disagree with me, that NAFTA laid out a template for trade agreements that encouraged and accelerated and rewarded outsourcing, not exports. And if you take that frame for NAFTA and you take that frame on the renegotiation, I think you do see that there are different ways of assessing whether NAFTA's been a success or not a success, like adding up the total volume of trade, exports plus imports, doesn't really get you where you need to go. And it does speak to this question about whether it's relevant or a good goal to talk about the bilateral or the NAFTA trade deficit. But, and this question of whether trade agreements should be about protecting the interests of multinational capital, that is to say, protecting outsourcing and accelerating outsourcing versus encouraging exports, is relevant to whether we see reducing the overall trade deficit with NAFTA countries as a relevant goal or not. So if I would lay out a couple quick principles that trade agreements should aim to spur exports and good jobs in all three countries, not corporate profits. And if you look at some of the provisions in NAFTA, like investor-state dispute settlement, the rule of origin, whether or not and how currency is included, and of course the labor and environment provisions, you start to see a balance of interests between the corporations that want to move production offshore and have certain protections, whether it's on intellectual property rights or investor state or financial services, versus actual market opening that is also at risk. And the second principle is that as a country we have both an obligation and an interest in investing at scale in our infrastructure and our workforce development. And that's something, if you look at the 3 North American countries, I think we all have that interest, and certainly in the United States we know we have fallen short. And the other piece that should go along with that is humane and adequate social safety nets and transition programs for displaced workers. And I think in that front, the US and Mexico are both inadequate. Canada has done a somewhat better job. And for a whole generation, both Democratic and Republican administrations and Congresses have failed on both of these counts. We really haven't done the associated national policies in terms of investing in our own infrastructure and development, social safety nets and transition programs that would make the kind of trade policy that is sought in NAFTA successful. And finally, the last principle is that trade agreements should be based on cooperative principles. They should be mutually beneficial, obviously. I mean, that sort of goes without saying, but I think you have to repeat it every once in a while. Not necessarily to the national corporate giants, but to the working people, and they should preserve democratic processes as much as possible. It's not always possible. Part of what a trade agreement does is yield sovereignty, but that yielding of sovereignty should be deliberate, and the principles that we are trying to uphold by yielding sovereignty should be ones that are accepted, and not just that, you know, a particular corporation doesn't like a particular regulation and wants to get out from under it, using a trade agreement rather than the democratic process. So what are we looking for? And I'll try to be quick. I'm never that quick, but I'll try. In the renegotiation, what do we learn from Monday's notice? So the first thing that we're looking for in the labor movement is transparency and broad participation. And so we did appreciate that there were the 3 days of hearings held. The AFL-CIO, as some of you know, submitted almost 50 pages of detailed comments with respect to what we're looking for. So you all can go look all that up. You can see that we've been as clear and as concrete as possible. And that's because what we want to do is put out our own benchmark. You know, I think this administration is a little bit unclear sometimes. Sometimes there's inconsistent things that come out of the administration. So what we want to do is lay out our principles, and then we can measure the progress against that 50-page document. So we do agree with the stated goal of reducing the trade deficit, strengthening rule of origin, and, you know, in terms of what Bill said about whether it's, I think the rule of origin is always for the participating countries, and the question is whether most of the benefits of the agreement should go to the signatories rather than to third countries. I think that's a perfectly reasonable principle, and one that we haven't done a good job in, certainly not in TPP. And the state-owned enterprises, I think the idea of disciplining state-owned enterprises is something that's still a work in progress, but we need to work on that. And we would agree with eliminating the Chapter 19 dispute settlement mechanism. But in terms of that the overarching question about whether NAFTA is an outsourcing agreement or an exporting agreement, we still, as I think folks know, are very critical of the investor-state dispute settlement, and I think that's sort of one of the things that people are going to watch in terms of whether there's a change in the overall balance of commitments, whether it is still about empowering multinational corporations to sue governments over regulations they don't like, or whether it's more about creating and supporting good jobs at home. So that's a key concern for us. We did not see in the 17-page document from Monday any detail whatsoever on investment, and if anything, it repeated some of the bland language about NAFTA investors should not be accorded greater substantive rights than domestic investors. But I think it left it open, and I think a lot of the things in the 17 pages are left vague on purpose, of course. And so, you know, I think today we can't definitively judge whether the administration is or isn't going to do this, that, or the other thing. They've left themselves, as they should, as they would, a lot of wiggle room. So there's vague language in that. In terms of labor and environment, let me just focus on labor for 2 minutes. 1 minute. That mostly what you see in that section is preserving the fast track of the TPP language, which, as you all know, we thought was inadequate. It was not good enough. We've had a lot of experience, 20-some-odd years, of trying to use the labor chapters, first in NAFTA and in subsequent agreements as well that were stronger than NAFTA, to protect workers' rights. And we've been frustrated. We've seen that the Guatemala case, which recently ended in failure for us, took 9 years to play out. And some of the language that was problematic for us in a sustained or recurring manner end up, you know, my view is a recurring manner is twice, but from USTR who tell us we had 6 different instances of the Guatemalan government failing to enforce its own labor laws and allowing the assassinations of people who tried to organize trade unions. Those 6 instances weren't considered recurring for us. So that was a problem. That's a loophole that doesn't work. In a manner affecting trade or investment between the parties. It may seem reasonable, but on the other hand, it also becomes an excuse to eliminate a lot of abuses, very flagrant abuses of workers' rights, that in our view, the labor market is a single entity, and so if you violate workers' rights, even in the public sector, it is very likely to have an impact on trade or investment, but the dispute panels have a hard time doing that. So let me wrap up, because we'll leave everything for the discussion, that, at the end of the day, I don't think we saw very much in this document that would lead us to believe we're in a completely different direction, that we are going to be transforming our trade goals or priorities or how this administration is going to act. But on the other hand, I think that is what we need to keep our eye on the prize, and we need to not dampen down our goals or our objectives, because if we do that, ultimately, what we're doing is ignoring this huge gorilla in the room, which is that NAFTA has failed. A lot of Americans, a lot of Mexicans, and a lot of Canadians. And we have to get right to the heart of that failure to have a real honest discussion between our 3 countries. I hope that will happen, and we'll wait and see. Thank you very much, and I'll look forward to your questions.
Thanks, Thea. Our last panelist is Bruce Hirsh. Bruce began his career, he worked for 8 years as a practicing lawyer, mostly for the law firm of Melvin and Myers, both in the United States and Japan. And after that, he went to government. Bruce was an associate general counsel at USTR for 2 years. He was then a legal advisor to the United States mission to the World Trade Organization for 2 years. He was then the deputy assistant at USTR for monitoring and enforcement for 5 years. He was then the deputy assistant USTR for WTO and multilateral affairs for 4 years. He was then, went up Pennsylvania Avenue to the Congress, where he was counsel to the Senate Finance Committee, first International Trade Council and then Chief International Trade Council. He went back to USTR, where he was the assistant USTR for Japan, Korea, and APEC. He's now a principal at Tailwind Global Strategies. And with that very hardcore resume, I turn it over to Bruce.
Great, thanks very much, Matt, and thank you, Rita, for the opportunity to be here. One of the challenges, of course, of going last is a lot of what you were thinking about saying or planning on saying has already been said in some form, but I'll try to find a few spaces in between what's been said, as well as go into a little bit more detail about rules of origin and disputed settlement. I'd first like to just comment on that intersection between the timeline issue that Sean raised earlier and the leverage issue that Matt raised. Matt pointed out that there are just a lot of asks in this document, and there's a lot of hard issues in this document. And wholly beyond the number of issues that Canada or Mexico might bring to the table, is the question of how what kind of timeline the Trump administration really has in mind for getting this done. Because to the extent that there is any sense of time urgency on their part, it's hard to see how a lot of these hard issues aren't going to be very hard to achieve. The second point, again, that's been discussed to some extent, is the whole Trump factor. And while, as a practical matter, it's hard to see it being in the United States' interest to pull out of NAFTA, the question is whether that might happen anyhow. And while Ambassador Gutierrez has pointed out, as Mexico has pointed out in the past, that it will not negotiate with a gun to its head, the question is, what if the gun is in the holster, and will that affect the way they approach these negotiations? Will they be thinking about, well, we have to at least be prepared for the worst and maybe be a little bit more flexible than we might otherwise be? But going on now to rules of origin and dispute settlement. Rules of origin is an issue where certainly you can optimistically go in and say better is always possible. There's a whole lot of folks who are saying do no harm, And that's simply a function of the fact that our regional supply chains at this point are so integrated, with intermediate goods passing back and forth across the border multiple times before they go into a finished product, that there's a lot of nervous folks out there about what might be done in connection with modifying rules of origin. Having said that, this is a high-profile issue. Quite remarkably, was a presidential campaign issue. Who would have ever thought? But it is, and so it's almost certainly the case that, notwithstanding the vague objective that was published on Monday, it's likely to be something which is pursued. The question is how. A lot of companies have, in a lot of different sectors, in their comments to USTR said it's working fine because they don't want disruption. There have been at least some who have said, let's use TPP. Those are the folks that typically found a more liberal rule in TPP. And then, there are some, including certainly metals, textiles, unions who want stricter rules very clearly. But what will that mean? In the context of autos, which was the high-profile issue in the presidential campaign, Secretary Ross has been quoted many times over the last several months in discussing the fact that the current rule of origin in NAFTA isn't working, and in particular, he has focused on a very technical element of it, which is something called tracing, the fact that there's this part-by-part analysis of origin, where some pieces or some inputs are examined very strictly and others are deemed originating and not treated very strictly. But the open question is, what does that mean for what the U.S. might try to do? Does that mean that they're going to try to drop this process altogether? Or does it mean that they're going to just simply add more products to it and make it a much stricter operation? That's a very open question at this point. But what we do know is that the auto companies themselves have at least gone on record as saying, don't change it. Again, presumably this is out of a concern that, given how complicated their supply chains are, they don't want to see disruptions. But again, it's difficult to see this being avoided by the administration. One point, a general point on rules of origin before moving on to dispute settlement, and that is, it is important to bear in mind that a rule of origin can backfire. Right now, U.S. tariffs on finished vehicles are only 2.5%. So if a rule of origin is too strict and it becomes too costly to try to meet that rule of origin, then a company can choose not to even bother. And if they choose that, then there are simply no incentives to use local production or local sourcing. And the true beneficiaries of a rule that's too strict would be non-NAFTA parties, since they're the ones who have no restrictions whatsoever on their content and can simply pay the 2.5% and then import. So there's certainly a balance to be struck here. On dispute settlement, there's a few different mechanisms that potentially are going to be discussed. One of them is the state-to-state dispute settlement under Chapter 20. One of them is Chapter 19, trade remedies review, which we've already discussed. And one is investor-state dispute settlement, Chapter 11. On Chapter 20, the state-to-state mechanism, there probably is room here for the parties to reach agreement. The biggest problem to date with Chapter 20 has been how easy it's been to stop it from even getting started by blocking the panel selection process. And in TPP, there was a lot of elaboration of various scenarios that could help prevent that from happening. So between that and the transparency elements, which are likely to be added and which are referred to in the objectives, whether it's public briefs and hearings, the opportunity for non-governmental actors to submit briefs, all of that is very possible and very likely. Chapter 19, we've already mentioned many times today. It's going to be a very hard issue, very controversial, very popular in Canada, extremely unpopular here in the United States among petitioning industries, in particular lumber. The administration has been extremely clear that they want to eliminate it. It was interesting to hear Ambassador McNaughton talked about the possibility of improvements, and well, certainly the big question is going to be, will the Trump administration be satisfied with that? Certainly, Chapter 19 has been controversial for its entire history, with many saying that it's not following the rules, that the rules are that they should be providing the same kind of deference to administrative proceedings as a U.S. court would, and it's questionable whether that's happened. Up on the Hill, as far back as over the early days of NAFTA, back even 1998, Senators Hatch and Baucus at that time already, at that point, put in a letter saying, let's drop it. And so, it'll be interesting to follow that. One other just point to note, which was that NAFTA predated the WTO. And therefore, the possibility of this kind of international review of trade remedy decisions wasn't available at that time. It is available now. With regard to Chapter 11 and investor-state dispute settlement, and as Thea noted, the objectives are vague. They're basically boilerplate taken from TPA. Interestingly, the draft objectives, which leaked, presumably they were accurate, back in March, did include a paragraph on improving ISDS, but that has been dropped. And so there's just a real question now as to exactly how they'll pursue it or whether they will. You might look to the objectives for other hints as to whether they will. There's a new objective on energy there, and it refers to preserving and strengthening investment disciplines. And certainly this is of great importance to the energy industry, as we saw at Tuesday's Ways and Means hearing, where representatives of the industry and energy industry were very strong in saying we need to keep investor-state dispute settlement. Other business representatives did as well, including a railroad company that has lots of assets in Mexico, and their point was that this infrastructure which they have in Mexico is actually supporting U.S. exports, and they want to protect that investment. So we'll see. The objectives are completely silent on the issue, so we'll have to really just wait and see. Just a couple of final observations. I think it's already been noted that the document does not refer to the tax issue at all. That also is something which was in the March 29th draft objectives, which is no longer there. So again, wait and see. And then just finally on that first point in the objectives on reducing the trade deficit, I think like much in the document, it's ambiguous. Does this mean that the administration is interested in trying to pursue direct mechanisms to deal with the deficit? Or does it mean that everything else in the document is designed to help address that problem? And that, as much as anything else, is an open question. I look forward to any questions you have. Thanks.
Great, thank you. I think it's time to open up for questions.